Under oath, Brigadier.
Yes, my lord, thank you.
Yeah.
Yes, it is the court, my lord. Morning again, Brigadier.
Good morning, Advocate Mnisi.
Remember, we were still busy with Exhibit JJ. I mean, Exhibit J, I'm sorry.
Yes.
Exhibit J.
Yes, I remember, my lord. A warrant of sustained comes statement.
Yes.
Yes, I remember, my lord.
Yeah. Now, she had an interview already with the first witness, who was Kelly Khumalo. Then the second witness that she interacted with was Zandi Khumalo.
Yes, my lord.
Yes.
In first speed, akhuluma naye kwakuSandi Khumalo tiye.
Now she says Zandi Khumalo, this is what she says in page 4 of her affidavit. The second witness was Kelly's sister, Zandile Khumalo. She told a similar version and gave a similar profile and facial description of suspect A. The only feature she adds was the eyebrows. She saw the eyebrows when suspect A lost his headgear during the scuffling with the deceased. She could not describe the second suspect.
Uthi guy mechaza lapha uthi wachaza into efanayo wasenika incazelo echaza ngobuso bakhe kamsolo uA and into ke athi yehluka lapho ayinezezela lapha amashiya uthi wabona ukuthi ususpect umsolo uA kwasuka lento ayigqokile ekhanda ngesikhathi bephushana nomufi.
Oh, sorry. No, got it. Yes, I see that, my lord.
You follow that exactly?
Yebona le.
Now she continues to say, the third person that I interviewed was Tumelo Madlala,
Umuntu wesithathu ke ngamkhulumisana naye uTumelo Madlala
who was much traumatized.
owayehlukumezekile kakhulu.
He saw the scuffling between suspect A and the deceased.
Uthi wabona udonsana phakathi kwamsolo A nomufi.
After hearing the gunshots, he ran off to one of the rooms.
Mayezoqhubha isibhamu wabalekela kwelinye lamagumbi.
He gave a similar description of suspect A.
Futhi naye ke wachaza umsolo uA ngendlela efanayo.
I showed him Kelly and his sister's compilation and was satisfied with the ID kit.
Ngamkhombisa ukuthi uKelly nodadewabo banikeza ngani wasethi ke wenelisekile ngalo umdwebo lo owenziwe.
He could not compile the second suspect.
Athi ke ubengakwazi ukuchaza umsola wesibili.
The fourth witness was Mr. L.S. Twale.
Omu wesineke ubaba L.S. Twale.
I surmise here that this should have been Mr. Longe Twala.
Lana ngicabanga ukuthi kwakulongwe Twala.
Nonetheless, Miss Steenekam says, he gave me a similar description of what happened at the scene.
Hayi wanginika incazelo efanayo ngokwenzeka endaweni isigameko.
He saw the scuffling between suspect A and deceased. After hearing the shots, he ran out to look for help.
Uthi wabona ukudonsana nosunduzana phakathi kwaSuspect A nomufi emva kokuzwa kuqhuma isibhamu wabaleka eyofuna usizo.
He could not describe the second suspect.
Akazange akwazi ukusichazela ukuthi wayenjani umsola wesibili.
Now she goes on to interview the fifth witness, who's Tima Kaleni.
Waseqhubeka ke nokukhuluma nofakazi wesihlanu Mr. Tima Kaleni.
But we know that Mr. Tima Kaleni was not one of the witnesses who was in the house.
manje siyazi ukuthi imakaleni akuye nomunye wofakazi ababesendlini.
And then she goes on to talk about the sixth witness that is called Spiwe.
Yaqhubeka ukukhuluma nofakazi wesithupha okuSiphiwe.
I will not waste the court's time because there's no name that is mentioned to be one of the witnesses who was in the house.
Futhi angeke ngidlane isikhathi senkantolo ngoba akuyena omunye ufakazi ukuthiwa bekhona endlini.
Then the last paragraph on page 5.
Manje ke paragraph egcina lapha ekhasini lesihlanu
says Lieutenant, oh no, it's C.O.L. Streichner, or it's Colonel Streicher, and I left for Fosslores detective to see Mrs. Khumalo at her house.
Mina no Colonel Streicher sasuka eFosslores detective siyobona uMrs. Khumalo endlini yakhe.
Now I surmise that this Mrs. Khumalo should be Kelly's mother. That's Ma Khumalo, the one that we're referring here at court as Ma Khumalo.
Manje lana ngicabanga ukuthi uMrs. Khumalo nokhulunywa ngolo esithi uMa Khumalo okuwumama kaKelly.
I interviewed Mrs. Khumalo at the neighbor's house.
Ngingakhuluma noMa Khumalo endlini ke kamakhelwane.
She gave a similar description of suspect A.
Naye ke wachaza umsolwa uA ngendlela efanayo.
I showed her that compilation and she saw a likeness in the face.
Ngabona ke mkhombisa ke umdwebo wathi wabona ngathi kukhona ukufanana la ebusweni.
She could not describe the other suspects.
Jakakwazanga ukusisiza ngokuchaza ukuthi wayenjani labanye ofakazi.
Now yesterday Brigadier, when I put it to you that did you in your investigation find a witness who was in the house who describes the first suspect, that is the gun-toting suspect, in a different way from which the witnesses who were in the house are describing him? You said yes, you can go and look at, if you afford an opportunity, you can go and look in one of the statements, was quite sure that such a description is there. This is the opportunity. Did you find anything which is not similar to what Mrs. Stienekam says, and to what the witnesses who were in the house are saying?
Manje kukhona yini owalethe incazelo yalo muntu owangena lapha ePettisbam kodwa ehlukile kulaba abamchazayo lo muntu ngisho laba ababesendlini.
Yes, my lord. So let's start here, my lord. I understood the question yesterday, or how Advocate Mnisi asked me. It was the description insofar as suspect A, in terms of the dark color, the complexion. That's where the contention was. He referred specifically in terms of the dark color. And I've said in my recollection, one will have to go through all the statements. Now, having gone through the statements, my lord, the only people that I was able to pick up who refers to the dark complexion, it's Longwe, I think Zandi, I'll just have to check, my lord. But it's not all the witnesses who were inside the house. The other, I think it's about 3 of them that give the complexion of a dark person. In other words, the first intruder being dark, referring to the complexion. The others are simply giving description in terms of the dreadlocks and the height, and then that goes to the same, that becomes the same situation when they describe accused number 2. But not all of them are saying the person is dark. And when I'm saying all of them, my lord, I'm referring to their statements. That is why I said, as much as Warrant Officer Steenkamp prepared the statement in preparation of the identity kit, if you read what is contained in her summary in relation to what the people inside the house are saying, I've said it yesterday that there's no consistencies, because Kelly Khumalo, for example, the first person she interviewed, refers to a dark person, refers to a revolver. You don't find it in a statement. if you go to other places where Zandi said she could not identify certain people, if you go, like Ms. Zandi Khumalo, the second witness, if you go to Zandi's statement, she says, I will be able to identify the intruders if I see them again. So you need to read this, my lord, with what actually the deponents have actually disposed. So yes, I was able to find statements where there is not dark color or complexion being mentioned of the first intruder.
Izolo ngizwisise kahle umbuzo futhi ke lo mbuzo ubuqonde ngokule ukhuluma ngebala la lo muntu okuthiwa wangena la kodwa ke uzofanele uma ufuna ukutholisisa kahle ufanele ufunde zonke izitatimende ngoba ngicabanga ukuthi bathatha kuphela la ehlanganisa khona uLongwe ethwala noZandi kodwa kubona bonke abathi lo owangena lapha wayenebala elinsundu abanye ke basebenzisa ke ama dreadlock nobude bomuntu and futhi abasho lutho ngebala lakhe kodwa uma usubheka lezi izitatimende zalaba ke abebekhuluma ngebala elinsundu akukho ungaguquguquki lapho kwestatement kwalento abayishoyo ngoba abanye basho lokho abanye basho okunye ngoba uma sibheka lapha uKelly yebo uyakhuluma ukuthi yebo wayemnyama lo muntu and futhi ukhuluma nangevolovolo uZandi yena uthi wayezokwazi ukuthi mhlawumbe mangathola ithuba akwazi ukubakhomba labantu so kuzofanele ukuthi ubheke zonke izitatimende ukuze ngitholisise kahle ukuthi konje bathini.
My lord, furthermore, the fifth witness that was interviewed by Ms. Warrant Officer Steenkamp, Advocate Mnisi said obviously because this person was not inside the house, he didn't go into what this person says. But what is prevalent as well, and that is why you have to look, because that is how I conducted investigation. You don't look at an incident and isolate it, you investigate holistically. Tim Makaleni, my lord, gave a statement where he says he saw 3 intruders coming directly from Khumalo's house. Directly, and he says one of those intruders was carrying a firearm. The statement is in the docket. So then it becomes prudent, for him to identify or rather to assist in the sketching of the identity kit. And I think that is why he assisted in identifying the person or one of the intruders, my lord. But he places himself in a position where he says he saw intruders coming directly from Khumalo's house, refer to that name, and one of them was armed with a firearm.
Manje uma ukuthi ufanele ubheke wonke amaphuzu owahlangana nawo ekuzameni ukuphenya ufanele ubheke konke awubheki into eyodwa kodwa ufanele ubheke konke ohlangana nawo ngoba siyazi ukuthi nanoma uthi Makaleni wayengekho endlini kodwa ke washo ukuthi yena wabona abantu abathathu bevela endlini bephuma endlini and washo ke nokuthi oyedwa wabo wayephethe isibhamu yikho ke kwakwazi ukuthi asize ukuthi kwenziwe loya mdwebo loya ukuthiwa identity kit.
And lastly, my lord, I've considered and agreed with Advocate Mnisi that not all the witnesses, where we differ, it's not to say all the witnesses describe the first intruder as dark. Where I've considered is that in terms of the description of the intruders, you have a bit of inconsistencies in terms of the description. There I concede, my lord. However, as I've said yesterday, the prominent and the main thing that you find in all the statements of the people who were inside the house is that they were intruders. The first intruder was shot, he was armed. The second one was told there was a demand of cell phone and money. There was a struggle and the gunshot went off and the deceased was then shot. That is consistent, my lord. It's insofar as the description, finer details of the description of the accused. For example, my lord, it was also mentioned, without taking it further, that somewhere, perhaps let me not go there. I would like Advocate Mnisi to lead me so that we don't step on each other's toes. Let me just leave it at that for now, my lord.
Okunye-ke siyazwana nobaMnisi ukuthi yebo kukhona ungahambisani kobufakazi lana khona la ukwehluka ukukhona ngoba ke nanoma nje laba abanye bechazela ukuthi umuntu wayelapha wayephethe isibhamu waye umuntu onebala elimnyama kodwa ke akusho ukuthi laba banye nabo bachaza kanjalo. Into ke nje abayishoyo ukuthi ke lo muntu wayemfishane wayephethe isibhamu nokuthi wafika wacela amafoni nokuthi ke emva kokuthi kudutshulwe lapho ke base beyaphuma babali ikona nje kuphela.
Yes, my lord, that's my answer.
Thank you, Brigadier. You know, I said that I would not waste the course time by referring to what Mr. Timakaleni is saying. Now that you're mentioning Mr. Timakaleni in an endeavor to try and justify the theory that accused number 3 could have been the person that was in possession of the gun or of the firearm. This is what Makaleni is saying. According to Mrs. Steenkamp, she says, the fifth witness, Mr. T. Makaleni, residing at Mozamo 3942, compiled the suspect of B, compiled the face of suspect B. He saw 3 unknown African males in the vicinity of the gas station, busy on their cell phones. He saw them again at Kelly's mom's house. Suspect B stood at the gate. He gave the following description.
Manje kumhlobo wesihlanu uthi Makaleni nje usho ke kuka Steenkamp uthi ke lana uthi lona uhlala emzamo 3942 uthi wasinika incazelo ukuthi kunjani ubuso kaMsola uB uthi wabona amadoda amathathu abantu abansundu bese duze negarage babekhuluma ke nje noma khale ekhukhwini wabo and uthi waphinda wababona futhi ngasendlini ka mama kaKelly umsola ke uB wayeme ngasesangweni wasenika ke nathi incazelo yakhe.
An African male, plus minus 25 years of age, plus minus 1.80 meters tall, slender build, medium brown complexion, clothing, black hooded top. Witness saw a golden insect in the upper teeth. Hairstyle, dreadlocks, facial hair. He had a mustache and a beard. He slave with a beard. Thank you.
Uthi ke lapho kwabona umuntu umAfrika wesilisa eneminyaka cishe ngaba 25 wathi ke ubude bakhe 1.8 meter and futhi ke lapho uyabonakala ukuthi wayengakhuluphele wayenje futhi ke nebala lakhe lalingakhanyi kakhulu laliphakathi nje nendawo uthi wayegqoke ihoodie emnyama and uthi wabona ke ukuthi unezinyo legolide ngenhla and futhi ke inwele zakhe kokwama dreadlocks and futhi ke wayenobu kusho ukuthi wayenamadevu futhi enentshebe.
He also had facial hair.
Futhi ke uyabonakala ukuthi wane nenwele ebusweni bakhe.
Now, 1.8 meters tall. It's somebody that is just, I'm 1.8 meter, I'm 1.82 meters tall.
Mina ke ngina ubude bami 1.82 wamameter.
So, plus minus that person could have been of my height. But importantly, Mr. Makaleni described suspect B.
Manje kusemqoka lana ukuthi uMakaleni ukhuluma ngomsolwa uB.
Now these are two individuals
manje labantu la abantu ababili
that should be separated in terms of the intruders who got into the house.
Bafanele bahlukaniswe njengabantu abahamba bayongena endlini.
You understand?
Ngizwisisa.
Yes, I fully understand and I agree with Advocate Mnisi, my lord. However, I think perhaps we didn't understand each other.
Okay.
So my endeavor, as Advocate Mnisi is putting it, it wasn't insofar as accused number 3, because I didn't say Makaleni identify accused 3. What I've said, I said the relevance, the endeavor that I was trying to put forward is that the assistance of Makaleni insofar as the compilation of the identikit, my lord, was necessary because in his statement, he says he saw 3 intruders coming out of Khumalo's house and one of them was identified, or rather he saw one of them carrying a firearm. I did not say that, and that's why I think there was a misunderstanding, that him assisting in the identikit was the drafting or implicating accused 3. I simply said because of that contained in his statement, it was then necessary for him to assist in the drafting of the identikit. Hence, he assisted in the compilation of the second intruder. So I was making it a point that the fact that he was not one of the people who was inside the house, although he was outside, but he was able to see the intruders running out of the house and assist in the drafting of the identikit of suspect B, the second intruder, which, so they were in the same page. But it was not to say I'm saying accused 3 or he assisted in the drafting of the identikit for the first suspect. I think that's where the misunderstanding was. We're on the same page.
Khona la besingazwani kahle ngoba Mnisi ngoba mina bengizama ukusho ukuthi ke uMakhaleni ubengakhulumi ngalomuntu umsola wesithathu futhi ke ukuthi usizo lwakhe beluvelaphi beliphuma nje ekutheni yena uthi wababona abantu abathathu bephuma endlini nokuthi khona oyedwa owayephethe isibhamu and yikho ke wakwazi ukuthi azosiza ekutheni kwenziwe lo yamdwebo le and ngoba yena wababona abantu abangena lapha hayi ukuthi ke wayezama ukuchaza ukuthi umsolo wesithathu wayenjani.
My lord, the court will also, just to support what I'm saying, that I'm not tip-and-toeing, is that the court will recall that when I was dealing with the very same exhibit with with Mr. Ramsipil, we dealt with this and I indicated that the correlation insofar as accused 2 is concerned, or collaboration, is that at that time in 2014 he was 25 years old. I was specific on this, the court will recall and the record will speak for itself, and I mentioned the issue of the black hoodie, which was then corroborated by Zungu, Constable Zungu, when he gave a statement that he saw accused 2 at a hostel at some stage wearing a black hoodie. So I'm saying this assertion by Makaleng was very clear that it relates to a suspect 2, not necessarily the first suspect.
Manje ikatalo uzokhumbula ukuthi ngesikhathi sikhuluma no Ramsipili kwasilana sasikhuluma ngomsolo wesibili ukuthi umsolo ngaleso sikhathi wayeneminyaka 25 and futhi ke uZungu iphoyisa la kwazi ukuthi kumbone lapha hostel labona ukuthi wayenehoodie le emnyama ngoba uthi yena wambona ese hostel.
Yes, that's my answer.
Thank you, Brigadier. My lord, yesterday I dealt with some correspondence or certain letters that came from the Legal Practice Council. I was missing their exhibit numbers. Those letters that are referred to are in paragraph 154 of the list of exhibits. The first letter is exhibit YY, and the second letter was exhibit Y2. I think they relate to the confirmation of the enrollment of Advocate Mchiako as an advocate with the LPC, but importantly, those were the exhibit numbers that I tend to refer to. There was also a charge sheet that contained another letter from Rustenburg that I also referred to. Thank you, madam. Thank you, Brigadier. Now, I again do not want to labor this point, Brigadier, but let me put it to you that in terms of the description of the person who had a gun when they got into the house of the Khumalos, the description by the occupants of the house of that intruder consistent. A dark-skinned person who had dreadlocks. That is the common denominator, if I were to borrow from your parlance. That is a common denominator. It's a golden thread that runs throughout their description of this suspect. A dark-skinned person who had dreadlocks. As I'm saying, that is what I'm putting it to you.
Manje malana ncazelo yalo muntu oyiphethe isibhamu lethwa yilaba ababesendlini ukuthi ke wayenebala elinsundu futhi wayenama dreadlocks and futhi ke lokho akuguquguquki bonke bayibeka kanjalo.
No, my lord, I disagree. Not all of them, and we can go through to the description. That's why I said I could pick up 3 of the people who were inside the house who relates to the dark skin, in terms of the first intruder. Not all of them. So it's not a general remark. That's why I indicated what is common in all the people that were in the house. Insofar as the intruders demanding cell phone and money, I've indicated those things. But insofar as the description, some of the witnesses that that were inside the house at the time are describing the first intruder as dark, but the others are not giving the complexion of him. And the statements are here to confirm that.
Futhi ke angivumelani naloko ukuthi bonke basho njalo ngoba abathathu kuphela ababekhuluma ngebala elinsundu. So okusho ukuthi ke akuyona into efana nayo kubo bonke le eshoyo into engathi ingafanana ile ndaba ye cellphone nokuthi bafuna imali ngoba abanye abazange balikhiphe nebala labantu.
Where the similarities or my lord, or rather where an impression is created as if everyone in the house are saying the first intruder was dark, it is contained in Exhibit J that Advocate Mnisi was taking me. This is now Warrant Officer Steenkamp's statement, because he says they are almost like conquering each other. But if you go to the statements, because these witnesses or the people who are inside the house dispose affidavits, my lord, they are not saying that, my lord.
Futhi ke into kenza ukuthi kubukeke sengathi bakhuluma into eyodwa yilento etholakala lapha ngisho laba ababesendlini ilento etholakala lapha ku exhibition J nalincazelo isithole lapha ku Warrant Officer Steenkamp. Kodwa ke uma siya estatementini siyubona lo mehluko ukuthi umehluko ukhona kulabo ababekusho.
As a court, please, without interfering with Advocate Mnisi's cross-examination, he's referring to Exhibit J, and if one looks at the description given by Ms. Kelly Khumalo, the report mentions in the middle of the report, African male in his mid-20s, dark brown, shiny complexion. Now, the word brown has been omitted in putting the proposition to Brigadier Gininda. It's important to keep that description in mind. Dark brown, shiny complexion.
Is it please the court, my lord? Now, Brigadier, you constantly, let me just write this down. Now, you constantly has been mentioning throughout your testimony that Kelly Khumalo is the mastermind behind the death of the deceased Senzo Meyiwa, not so?
Kaningi emfakazini bakho uveza ukuthi uKelly Khumalo uyena ophambili kulesahlakalo sokubulawa kamufi uSenzo Meyiwa.
Yes, my lord, based on the investigation, not my assumption. I mean, I think I made references to where her name comes from, you know, and that starts from accused one going up to, you know, and then obviously then the investigation that we conducted. So, but it starts from there, my lord, going up.
Yeah, but kuvela kuphenyo esalwenza akukona nje okuphuma engqondweni yami engizicabangela kona kodwa kuvela kuphenyo esalwenza yebo na kuloko kwalethwa umsolo wokuqala.
Thank you. Is this a narrative that is also shared, or that was also shared by the prosecutors who assisted you in this investigation?
Manje shothi lokhu umbono walethwa futhi nayilaba shushisi ababenisiza kuphenyo lweni.
I don't see the relevance of this question. There was a decision to prosecute the current accused before this court as to what view the prosecuting team held is irrelevant. So we have to focus on the accused that are before this court.
Please record. My colleague should not be understanding me as not been concentrating on this case. The witness, my lord, has testified many a times that there were certain things that it did not do because it did not have specific instructions from the team of prosecutors who were assisting him in investigating this case. Consistently maintained that Kelly Khumalo is the kingpin in the assassination of the deceased in this case. I don't know, therefore, on what basis it is then alleged that the question that I'm asking him as to whether or not the team of prosecutors who assisted him shared the same view that Kelly Khumalo was a kingpin in this case. I don't know on what would then be the irrelevance of that question, my lord. Thank you, my lord. Did the team of prosecutors who assisted you in this case also share the same view? Were they part of that narrative that Kelly Khumalo is the kingpin?
Nje laba ke ababekusiza ekuphenyeni nabo babe nawo lo mqondo yini ukuthi uKelly Khumalo uyena wayephambili kulokho.
So my lord, I wouldn't say there was a narrative from the prosecutors. Evidence that was collected, my lord, at some stages I indicated was presented to the DPP, and further instructions insofar as Ms. Kelly Khumalo were given, up to the point where we read the statement that I made in November, my lord, and I indicated that there was no decision taken at that stage, you know, to bless the arrest of Ms. Kelly Khumalo. So there wasn't an objection. It was a question of further instructions and the adoption that the NPA was taking at the time, my lord.
Engingakusho ukuthi ke lokhu kwavela kubufaka kubuphenyi esasibenza and futhi ke sakudlulisela ku DPP kodwa ke njengoba bese ngichazile ukuthi kwakungena sasingekho isinqubo sokuthi ngaleso sikhathi akaboshwe uKelly Khumalo.
That's my answer, my lord.
I did not get really what my answer to the question, to my question is, because the question is very clear. Was the team of prosecutors or was it part of their narrative, their viewpoint that Kelly was the kingpin in the assassination of the deceased in this case, irrespective of whether Kelly Khumalo was charged or not? Did they hold that view in terms of your discussion? Remember, your discussion is not privileged. It's just not privileged, which is the reason why you had to come and tell this court that they gave me these instructions, they did not give me those instructions, I did this because of what they told me, they guided me here and there and there and there and there and there. Do you understand? Now,
I understand.
the question is, was it their narrative as well that Kelly was a kingpin? Thank you.
The witnesses answer that question. Must he repeat his answer? If so, what is the reason why he should repeat the answer that he's already given, Malo?
Maybe I did not get your answer, Brigadier, and there is nothing wrong in me requesting you to repeat your answer. There's definitely nothing wrong in requesting a witness to kindly repeat your answer.
Angizange ngiyizwe impendulo yakho, sengiyacela ukuthi ngicela ungiphindele impendulo yakho.
My Lord, the essence of my response was that there was no decision taken. Insofar as the sharing of the narrative, my understanding, and this is how I've been dealing with the NPA from time memorial, you conduct investigation as a police officer, you present the evidence to them. They decide as to whether to enroll the matter or not. And then if there is a need for further investigation, such will be communicated. And I've testified about this, my Lord. So I'm not so sure if I can take it further than this insofar as what the advocates, because I can't get into their minds. What I know is what I presented to them and the responses that I've got, my Lord.
Akuzange kube nesinqumo esathathwa ukuthi sonke sizobona kanje. Futhi ke mithina ke umsebenzi wethu ukuthi kwakuphenya sithole sikutholayo ebese sidlulisela kubona. Kube yibona ke abathatha isinqumo sokuthi lolu daba lolu bayadlulisela inkantolo. Uma ukuthi khona obulunye uphenyo abalidingayo, yebo sasikwazi ukuqhubeka kanjalo, kodwa akukho okunye engachaza ukuya phambili ngalokho.
Thank you, Brigadier. Let us embark upon a standard 3 approach. Was it part of the prosecutors who were assisting you? Was it part of their narrative that accused number 1 is involved in the commission of this case?
I beg your pardon? The relevance of a standard 3 approach. We submit, my Lord, that the court has referred to the case of
I thought that case I gave you guys.
Azaf, and
here's a brigadier.
Yes.
It's being referred to as a standard 3.
Yes, and
You must approach him like a standard 3.
No, with due respect,
Okay,
that
I'm
is
not
what
going
I'm
to
saying.
argue that point. That's how I view it.
Yes, but my Lord,
Let's resort to a standard 3 approach.
no, I am saying, let me take it step by step so that we understand each other. But I'm not saying that the brigadier is a standard 3, my Lord. I would not have intended to say that. I am saying, let us simplify my question in the following sense. Brigadier, let me put it this way. Let me simplify my question. Let's not make meat out of the fact that, let us not make a mountain out of the ant small that I said, let us have a standard 3 approach. But what I intended to convey to you is that let us take it step by step. Maybe language is failing me. Thank you, Brigadier. But if you feel a little bit disrespected, my apology in that regard. Thank you, Brigadier.
Understood, madam.
Thank you. Let us take it step by step. Now, was it part of the narrative of the team of prosecutors who assisted you that accused number 1 is complicit in this case?
Futhi kwaku umbono wobeshushisi bonke abanensizana nabo ukuthi umsola uqala naye ke wayethinteka kulolu daba.
My Lord, accused number 1 has been charged. What is the relevance of that question?
I understand accused number one was charged, but was it part of their narrative that accused number one is complicit in this case? Yes or no?
Funa ukwazi ukuthi-ke kwakuyindlela ababona ngayo yini ukuthi-ke umsolwa wokuqala naye wayethinteka kulolu daba.
My Lord, perhaps to assist our answer this way.
Yes.
All the accused, 1 up to 5, when the memorandum was taken to the DPP, there was a decision to indict all of them on the charges, on the 5 charges that are before court, as per the indictment. That decision was taken. Insofar as Ms. Kelly Khumalo, further instructions were given for me to do. And that is why the statement I read here in court, where I was directed by Mr. Ramsipili, stated the date of November 2014. It was part of those further instructions to say, follow these instructions and then bring it back. And then subsequent to that, then the warrant was not signed. But there was never an objection to say we should not pursue this. I don't know if it will assist, but I will not be able to quote word for word as we're sitting there what the advocates were saying. But there was a desire to say, let us get more evidence to connect. Hence I said, my Lord, before this accused appeared in October, we had some evidence against Ms. Kelly Khumalo, which I've explained in this court. Later in November, we had more. We even dealt with the cell phone numbers. That was part of the prosecutorial driven investigation. So there was a working together between myself and the prosecution. But insofar as the ultimate decision to prosecute, my Lord, that lies in the hands of the NPA. And I think it will be dangerous for me to venture into that area as to what informed them. But there was a working together in terms of what should be done with regard to the evidence or the pointers that implicate Ms. Kelly Khumalo.
Isinqumo esaphuma sokuthi-ke umsolo wokuqala ukuyofika kwesihlanu bangathweswa amacala, kodwa-ke akuzange kuphume incwadi ephuma kwa-DNA echaza ukuthi-ke kufanele kusetshenzwe kanje. Kodwa-ke kwaphuma-ke enye-ke instruction evela eyalethwa kumina mayelana no-Kelly Khumalo. Kodwa-ke into eyikhona nje ukuthi sasifanele siqhubekele phambili senze umsebenzi wethu. And-ke isinqumo-ke esavela ko-prosecutor esasivela ku-NPA, and thina sasisebenzisanayo nokuthi sizame ukuthi sithole ubufakazi obungasiza ukuthi sizwisise kahle indaba kaKelly Khumalo.
Yes, my Lord.
I'm still struggling to get my answer on whether or not the fact that Kelly Khumalo is a kingpin in the murder of Senzo Meyiwa was part of the narrative that the team of prosecutors, actually let me not say the team of prosecutors, but the office of the DPP Pretoria had when they decided on this matter. I haven't received my answer. And I don't know what is the difficulty in saying, yeah, no, DPP Pretoria was of the view that Kelly was a kingpin in this case. However, she could not be charged because of this and this and this. That would have sounded better. But to simply decide not to answer my question, clouding it with a whole lot of lengthy explanation, I really don't think that assists the court. But nonetheless, I realize that is an objection from my colleague.
As a court, please, my Lord, and we don't want to belabor this point. The witness is clear that the discretion to charge lies with the Director of Public Prosecution. He presented a memo, and this is the decision was taken by the Director of Public Prosecutions. He cannot take it any further. He said, he cannot, as he put it, go into the minds of, the Office of the Director of Public Prosecutions. I think my learned friend will unfortunately have to live with that answer.
And unfortunately, I am not prepared to live with that answer. But I do realize that it's a very difficult one. But nonetheless, let me proceed. The reason why I am asking this, it's because in terms of the law, when a person gets indicted at the High Court, in terms of Section 144 of the Criminal Procedure Act, the state must inform the court the facts upon which they are basing their allegations against those that they've indicted before court. That is law, which is the reason why I am asking you that question. Do you understand?
Usho ukuthi isizathu ke ukuthi ngibuze kanje ukuthi ke ngaphansi ka section 104 umthetho ubugebengu ukuthi ke umshushisi ufanele ayitshele inkantolo ukuthi yini indaba befuna ukuthi bathwese umuntu amacala futhi basebenzise ziphi izathu.
My Lord, I understand. However, and I go back again, my part as an investigating officer, and exactly that, my Lord, was done, and the matter, it's a question of separation of powers, and I've explained this, my Lord. The docket was taken to the DPP, as is normally done, for a decision. A decision was taken. Now, for me, my Lord, it's not a difficulty, but I can't speak on behalf of the NPA. It's separated, my Lord. I did my part. I produced the evidence that we had insofar as this accused and what pointed to Ms. Kelly Khumalo. It's a normal, that's how it's done, my Lord. You present it to the NPA, then they will communicate their decision to you as they've done in this instance. Now, I'm not sure, my Lord, how do I then speak on behalf of them? I think the NPA in this situation, my Lord, are better vested with the knowledge of giving Ms. Advocate Mnisi the answers that is seek, because I can't speak on their behalf, my Lord.
Mina ke into indlela engizwisisa ngayo ukuthi umsebenzi wethu ukuthi njenge umuntu ophenyayo siyaphenya thina and mase siqedile ngale sithatha le docket silisa kwa DPP uyena uzothatha isinqumo sokuthi uqhubeka kanjani. Angikwazi ukubakhulumela abaka NPA ngoba thina owethu umsebenzi phela ukuphenya mase siphenyile bese sidlulisela kwa DPP ibona abathatha isinqumo and futhi angikwazi ukuthi ngibakhulumele ibona abangasikhulumela ukuthi indaba ethatha isinqumo esinje.
Same with the section or the law that Advocate Mnisi referred me to. I'm not sure, my Lord, how best can I assist him there. I mean, that lies between him and I think the court and with greatest respect, the Advocate Baloyi. Because what do I say, my Lord? That's not my terrain as well.
Futhi ke nangumthetho ayikuyafana nalapha akukho mina engakwazi ukusho ngoba akuyona into engathi ngifanele ngingenelele leyo angayikhuluma mhlambe ke no Advocate Baloyi kodwa mina ngikwazi ukuyingena leyo ngoba akuyona indawo engisenzela kuyona.
Yes, my Lord.
Now, you're mentioning that you investigated the docket, you gathered all the evidence and presented it to the state. Now, was it part of your, before I get to there, and then after submitting that document, then the state went on to make a decision to charge the 5 accused persons that are before court here, and they gave you instructions to go and issue out warrants of arrest against them, not so?
Manje ke emva ukuthi ke uze uphemo wakho uphenyo lwakho wathatha ke le case wayisa ke ku bashushisi bayibheka ke base bethatha isinqumo sokuthi ke baqhubeka nokuthi babathwese icala and emva kwaloko ke istate ke sasisibuya ke sithi ke sebengashashwa bangakhishwa ke nama warrant ukuthi bangaboshwa labantu kunjani.
My Lord, the first part is correct. A decision was taken and then an indictment was sent to me. I'm not sure if there was instructions to say go and get warrants of arrest. I mean, as I've said before, my Lord, J50s are a way of bringing the accused persons before court because a decision was already taken that, they're indicted for these charges. I then took that route, my Lord, of applying for J50s as per the affidavit that I disposed, and then that was solely granted, my Lord, and then the accused were brought before court.
kuyiko kodwa ke okwesibili akunjani ngoba zange kube nama-warrant of arrest noma incwadi zokubopha ezakhe. Thina ke esacela nje ukuthi sicela ama-J50 ngoba iwona esawasenzisa ukuthi abantu abalethwe enkantolo njengoba ngishilo kwa-affidavit yami.
Thank you, Brigadier. Further, I think that part of the instructions in that indictment was that they should be arraigned for trial in the High Court.
Futhi ke kuyisa phambili lokho ukuthi kwathiwa abayiswe abahambe ke beyovela enkantolo ephakeme.
I suppose, my lord, I'm just not sure word for word now because I'll have to go through to the indictment, my lord. But I suppose if Advocate Mnisi saw it recently, I will not dispute that.
Angeke ngiphikiseke lokho uma ukuthi u-Advocate Mnisi akudala ekubonile anginaso isiqiniseko sokuthi kunjalo kodwa ngifake ngibheke.
Yes, that is how the decision should have been penned. But nonetheless, which is the reason why they are before court here. But my question, therefore, is, when you submitted that document, was it part of your investigation that you submitted to the office of the DPP that Kelly, before they took that decision, that Kelly Khumalo is also complicit in the murder of Senzo Meyiwa?
Manje musuzofaka lezi ncwadi zakho kwa-DPP wakufaka yini nokuthi lo Kelly Khumalo yathinteka kuleli cala?
My lord, yes, I presented all the evidence as it is, and as I indicated, part of my recommendation or request was that she should be charged, but then there were further instructions insofar as she is concerned at that stage, my lord.
Yebo ngafaka konke kulezi ncwadi engazifaka kwa-DPP and futhi ngasho ke nokuthi naye ufanele athoswe icala.
And based on your investigation, you were satisfied that there were reasonable grounds to believe that there was a reasonable suspicion which you formulated based on your investigation to believe that she is or was complicit in the murder of the deceased.
Ngithi wena ke wawenelisekile ngokuthi ke uyasoleka naye and futhi ke wawukholwa ukuthi kufanele naye athoswe icala.
Yes, I was, my lord.
Thank you.
Yebo kunjani.
Now, this is what the state told this court in terms of Section 144, subsection 3A of the Criminal Procedure Act, which is called the Summary of Substantial Facts. And I'm going to read it paragraph by paragraph. It has got 12 paragraphs, but I'll try to be very brief and very precise. This is how it reads.
Once again, what has got the summary of substantial facts to do with the witness? The witness gives evidence, said he presented the docket to the DPP and the DPP exercises discretion. If my learned friend has got the legal argument to make out of summary of substantial facts which are not binding on the state, it's for him to present that argument to the court and not to this witness. We submit that his current line of cross-examination, my lord, is irrelevant as far as this witness is concerned.
As it is the court, my lord, I think that is it's a misdirection. It's a misrepresentation of fact. It can't be had to be said that an information that relates to the investigation of a case wherein an investigating officer is under oath and is taken up on his investigation, then it is argued that that line of cross-examination is irrelevant. What is it that I am coming up with which does not have to do with this case in my line of cross-examination? I dare my colleague to stand up and say, in terms of what you have said now, has got nothing to do with this case, then I would say, yeah, no, they are making a mistake. But everything that I've said so far has got everything and anything to do with this case. I've never spoken about anything that has got nothing to do about this case. Unless, of course, the guilty are afraid, I would understand. But up to thus far, there is nothing that I've come up with which has got nothing to do with this case, man. Definitely.
Yes, Mr.
Well, I don't know what daring and the guilt refers to,
Maybe
but
let's read section 104.
yes. But such obnoxious comment notwithstanding, my lord, we submit that this witness testifies about the course of the investigation, what the DPP has decided, and what the Director of Public Prosecution has formulated in the indictment, in the summary of substantial facts, has got absolutely nothing to do with this witness. And it was on that basis, my lord, that we made the submission that this line of cross-examination is relevant to this witness. He was not party to the compilation of the summary of substantial facts and the indictment. And we don't want to repeat ourselves, my lord, but we submit that that line of cross-examination should be disallowed. Did the court say I must read
Yeah,
our
yeah,
section
so that's it.
144?
People understand what we are about. Because we're quoting sections which maybe some people are not even aware what they say. I
Right.
mean,
The heading to section 144 is charge in superior court to be laid in an indictment. It's a very long section. I'll read the whole of it. Subsection 1. Where an Attorney General, now the Director of Public Prosecutions, arraigns an accused for sentence or trial by a superior court, the charge shall be contained in a document called an indictment, which shall be framed in the name of the Attorney General. Subsection 2. The indictment shall, in addition to the charge against the accused, include the name and, where known and where applicable, the address and a description of the accused with regard to sex, nationality, and age. Subsection 3A, where an Attorney General under Section 75, 1213B or 1222 Roman figure 1 arraigns an accused for a summary trial in a superior court, the indictment shall be accompanied by a summary of substantial facts of the case. That is what we are currently debating. A summary of substantial facts of the case that, in the opinion of the Attorney General, are necessary to inform the accused of the allegations against him, and that will not be prejudicial to the administration of justice or the security of the state, as well as a list of the names and addresses of the witnesses the Attorney General intends calling at the summary trial on behalf of the state, provided that, Roman figure 1, this provision shall not be construed that the state shall be bound by the content of the summary. This is the point that we've just made. Roman figure 2, the Attorney General may withhold the names and address of a witness if he is of the opinion that such witness may be tampered with or be intimidated, or that it will be in the interest of the security of the state that the name and address of such witness be withheld. Roman figure 3, The omission of the name or address of a witness from such list shall in no way affect the validity of the trial. In this matter, there were certain names that were omitted. Roman figure 3b, where the evidence for the state at the trial of the accused differs in a material respect from the summary referred to in paragraph A, the trial court may, at the request of the accused, and if it appears to the court that the accused might be prejudiced in his defense by reason of such difference, adjourn the trial for such period as the court may seem adequate. Subsection 4, Roman figure 1, an indictment together with a notice of trial referred to in the rules of court shall, unless an accused agrees to a shorter period, be served on an accused at least 10 days, Sundays and public holidays excluded, before the date appointed for the trial, the Roman figure 1, in accordance with the procedure and manner laid down by the rules of court, by handing it to him personally, or if he cannot be found, by delivering it at his place of residence or place of employment or business to a person apparently over the age of 16 years and apparently residing or employed there, or if he has been released on bail, by leaving it at the place determined under section 62 for the service of any document on him, or Roman figure 2, by the magistrate or regional magistrate committing him to the superior court by handing it to him. Then subsection 4b, a return of the mode of service by the person who served the indictment and the notice of trial, or if the said documents were served in court on the accused by a magistrate or regional magistrate, an endorsement to that effect on the record of the proceedings, may, upon the failure of the accused to attend the proceedings in a superior court, be handed in at the proceedings, and shall be prima facie proof of the service. Then lastly, subsection 4c, the provisions of section 55, 1 and 2 shall mutatis mutandis apply with reference to a notice of trial served on an accused in terms of this section. So, my Lord, this simply buttresses the point that was made by the state earlier on, that the DPP, in his opinion, has set out a summary of substantial facts, and this witness can be of no assistance as far as that is concerned.
Let's hear you, Mr. Mnisi.
As it please the court, my lord. May I respond?
Hello?
I'm saying, may I respond?
No, you must address me on the law, because you
That
say...
is what I'm saying, my lord.
Also, you're saying?
I'm saying, may I respond?
Yes.
Yes. I think my colleague is running away from telling the court about what you read being a prejudice.
What?
Prejudice to the accused. These accused persons, my lords, have been arraigned to this court to answer the allegations that are contained in a summary of the substantial fact. And there is nowhere in the summary of the substantial fact where Kelly Khumalo is mentioned as a kingpin. Instead, in the summary of the substantial fact, Kelly is mentioned as a victim. Now, all along, throughout the testimony of Brigadier Gininda, Kelly Khumalo is branded as the kingpin, the person who organized the killing of the deceased, which is the reason why I am asking if at the very inception, at the drawing, at the preparation of the summary of the substantial facts, the state was aware that Kelly was a kingpin, so that when it decided to draw this summary of substantial fact, that should have been a factor to be taken into account, so that when these accused persons come and answer on the allegations that are against them, they know that amongst others, we are before this court to answer allegations that we were in consort. We worked together with Kelly Khumalo to assassinate Senzo Meyiwa, and that is not there. They are now expected to answer on something that was initially not put to them at the beginning of the trial. Remember, my lord, when the charge is being put against this accused person, the summary of the substantial fact is also read into the record. That is part of the charge sheet. There is nowhere where they were called upon to come and answer that they worked together with Kelly Khumalo. That is the reason why I am basically asking, and I'm not trying to indict any person. I'm getting somewhere with this line of cross-examination as to whether or not at the preparation of this indictment was the state aware that Kelly Khumalo, without Kelly Khumalo, would not have been here basically. As per the testimony of Brigadier Gininda, we would not have been here because accused persons would not have had anyone to come. According to the allegations of Brigadier Gininda, these accused persons would not have had anyone to entice them to go and kill Senzo Meyiwa. But that is not contained in the summary of substantial fact. It doesn't matter, my lord, whether a person is charged or not charged, but the summary of substantial fact must contain the information that is contained in the case docket, so that when the accused persons are confronted with that allegation, they are able to respond accordingly. And that has not happened in this case, which is the reason why I am compelled to find out, because now they are expected in the middle of the trial to answer to something that has not been there at the inception of the trial. There's nothing wrong in me finding out whether or not at the time at which the decision was made, the state was already aware that Kelly Khumalo was a kingpin.
But you're arguing something different.
No, okay, my lord, let me hear. When the court says it's different, in what way, my lord?
No, let's play your question first, because you're into the merits, etc.
No, I'm responding to the state, my lord.
What were you responding about the irrelevance of this witness being cross-examined on the content
Yes,
of the indictment,
yes.
which, according to you, you're saying it's not
Yes.
relevant for this witness because it is the
Yes.
Director of Public Prosecution
Who
drafts
decides? Yes,
the indictment, including even that panoply of facts.
yes.
And that you also say that, but even that also doesn't bind the state.
Yes.
I thought that was what we were talking about.
Yes,
Now we're talking about Kelly Khumalo.
No, my lord. The Director of Public Prosecution, yes, does draft an indictment, but he's drafting an indictment based on what facts?
No, fine. You
Who
can, you can
brings the
argue-
facts to them?
Mr.
Yes.
You can argue those facts. But if you read that act,
Yes.
it says in
The
the
section.
It
Yes.
says in the opinion of the Director of Public Prosecution,
Yes.
not this witness.
That is correct, my lord. But now, if it is in the opinion of the Director of Public Prosecution and
Yes.
the witness includes something which, in the opinion of the Director of Public Prosecution, has not been included here, must we then fold our arms and say no? Because the Director of Public Prosecution has decided not to include this, we should also not take this witness on
you
that
should
evidence.
then you should have requested further particulars.
My lord, we did
No,
not.
no, that's the procedure.
Yes.
Am I correct, sir?
Yes.
Otherwise, we'll be here the whole day. When
Indeed.
you are hit with, your client is served with an indictment,
Yes.
you've got a right to request further particulars and further and better particulars. Did you do that, sir?
Let me respond, my lord.
Yeah.
Yes.
Yeah, fine.
There is no way where in the indictment it is mentioned that Kelly Khumalo is a kingpin. Had that been mentioned from the onset, we'll definitely have requested further particulars. There is nowhere in the indictment where it is mentioned that Kelly Khumalo is a suspect. Instead, in the indictment, it is specifically mentioned that Kelly Khumalo is a witness. How could we then have been enabled to request further particulars when we did not know that Kelly Khumalo, in the mind of the investigating officer, Kelly Khumalo is a kingpin.
But Kelly
This-
Khumalo, sorry.
Yes.
Kelly Khumalo is not charged in this court. I don't see her.
Yes, she is not charged, my
Yeah,
lord. But
so
the fact
why should I respond to that? I only respond to persons who are charged.
that is
Where
correct.
there's litis contestатio
Yes,
between the accused and the state.
Yes,
Kelly Khumalo, I don't know.
Yes, my lord. Her not having been charged, my lord,
Yeah, you can argue that.
is not
Okay,
it's not a.
ask that very question
I-
to this witness. Every question you want to ask him, ask him.
My lord,
May I request a short adjournment, my lord? It's already tea time. I think it's already 11:15. May I request a short adjournment? In any event, I also need to respond to the call of nature as well, my lord. I come and pursue this point when I come back. Thank you, my lord.
Yes,
my lord, before we adjourn, with your respect, my lord, for the sake of
Nature, no, it's killing me.
okay, 15 minutes.